I'm Rob Califf from Duke, and I'm privileged to be chairing this session in which we're going to be discussing some interesting issues about policy needs. I feel like the whole discussion has really been about policy needs, but we're going to focus in on some particular parts that may be at the fulcrum here. And the objectives we were given by the committee were to spotlight and differentiate real and perceived policy barriers to greater use of large sample trials, highlight examples of ways that these may have been dealt with or overcome, and anticipate potential policy issues as trials move to leverage electronic systems. And again, I think a lot of the discussion has already covered that, so we're going to focus on some particular areas related to personal health information and the ethics that are involved. So my co-panelists are seated in front here. Ruth Faden, who is Professor of Biomedical Ethics and Director of the Johns Hopkins Berman Institute. She's a member of the IOM and a fellow of the Hastings Center, and a great resume. I think it's going to be a tremendous discussion. She has some work which is near publication that we think that will be very interesting to talk about. Then Devin McGraw is the Director of the Health Privacy Project. This project is focused on developing and promoting workable privacy and security protections for electronic personal health information, something that we haven't talked that much about, but it's at the core of some of the issues that came up and is a reason for a lot of the complexity of what's been discussed already. So what I'm going to do is open with 10 minutes on background, and then the two panelists will both speak for 10 minutes. We should have a half an hour for discussion. See if we can have the first slide. So just first, my conflicts related to the opinions I have. I've conducted trials with all the sectors I think that are here today and identify with a lot of the issues depending on which kind of trial we're talking about. All of my industry relations are on a public website. And I recently have two leadership roles that caused me to have a vital interest in success of large sample trials as part of my job to try to make them work. So I'm not a two-tailed tester of large sample trials at this point. I'm really more trying to figure out how to make them work. So just so those of you who don't know can understand where I'm coming from, I had the good or bad luck, depending on how you look at it, to start out as a coronary care physician just in the period before we understood that blood clots cause heart attacks. And we sort of went overnight from 3 weeks of bed rest, prayer, Lasix, and morphine to opening coronary arteries 24 hours a day and saving lives. But I think what was really remarkable about that time related to this meeting is for reasons that are still, I think, cultural and not explained by any rational process, it just became the norm that people expected to participate in clinical trials. And we talk about interrupting practice. What could be a more difficult thing to interrupt than someone in your emergency department with 10 out of 10 chest pain and a 1 in 5 chance of dying in the next 30 days, and taking the time out to get consent, randomize, administer a treatment, and collect the data. But it was just done because that was what was expected. There was not a lot of resistance. There was a lot of enthusiasm at the time. And the result has been a dramatic reduction in the risk of death. I think not just because new therapies were developed, but because of the cultural norm that people participated in trials, the answers were obtained, and then they were implemented in a relatively systematic fashion, not just in the U.S., but on a global basis. And when PJ was talking about hope, that was really an outgrowth of the original work from the acute era into the more chronic era. So as we think about policy, I always love to go back to this document because it was a really sentinel time for me in terms of thinking. A lot of you remember this time when Elias Sarhouni took over the NIH. He convened a lot of people in what was called the roadmap, and we were allocated time to sit around with smart people and learn from each other and try to think of how things ought to be. So a lot of us were involved in re-engineering the clinical research enterprise we finally came to know of these as Zerhounigrams. I'm sure they came from a consulting firm of some type. But on the one axis, you see level of difficulty. The other axis is time. So this was 2002, so you'll notice the timeline is out to 10 years. And we started with a situation where everything was disaggregated. Electronic health records were present in a few HMOs, pretty much not present elsewhere. But it seemed to us that within 10 years, we could be up at the upper right-hand corner, which is the National Clinical Research System that creates effectiveness data that moves rapidly into the community, and data on outcomes and quality of care, sustained efficient infrastructure to rapidly initiate large clinical trials, scientific information for patients' families, and advocacy groups. And what I think has happened is that the technology has arrived actually a few years ago. There are no technological limitations to this future state. The issues that we have are the things we've been talking about, which are mostly cultural, and which I'm sure our panelists will straighten us out about how it ought to be. My view of the world from this evolved, and this is a 2007 article in Health Affairs, that, you know, if you think about the system that we described as electronic health records came on the scene, and we began to understand more about how a learning health system might work. In my view of the world, the center of medical practice shouldn't be biology, although we shouldn't ignore biology. Obviously, the center of medical practice should be measurement and education, because if you want to know what the patient should be advised to do or how to make a decision together, the fundamental basis for that should be the evidence about whether the recommendation is the best recommendation for that person. And so one can easily envision a system where if the right trials are done and you get definitive evidence, and you then develop practice guidelines from high quality evidence, and then you measure things continuously. And I think a number of speakers have already talked about the role of registries and EHRs as part of the backbone, not just EHRs. I think you now have a continuous learning system in which many people can participate. Now, as I was looking at this last night, at the time we wrote the article, we identified 12 things that needed to happen with regard to policy to make this work. And it was a little bit gratifying, not for me personally, because I had nothing to do with it, but if you look at what's been talked about today, every one of these areas has moved along really substantially. But as I said in the last session, I think we've arrived now, not just in terms of technology, but the theory is there, which I'll have something to say about that on the last slide. The problem is implementation and what the foot soldiers are actually doing. How does it work in practice? So the conceptual case many people have made, but just to give you my personal spin, we know that over 85% of recommendations from clinical practice guidelines are based on low quality evidence. And we also know now, because we have clinicaltrials.gov, which is imperfect, but still something that was unimaginable 10 years ago, that we would have such a record of all the clinical trials essentially being done. We know that the system, the way it's currently working, could not possibly close the gap. And in fact, the gap is going to get wider because as technology continues to evolve, the number of questions will grow, and our capability of getting things done the way trials are currently done, just not there. But technology itself is no longer a limitation. We really do know how to determine the best treatment, and we know how to determine the best way to deliver it. The question is, why don't we just do it? And this is where the policy comes in. So then that takes me into the rapid learning phase that I'm in right now as part of the health systems collaboratory that you've already heard about. But just to give you a little more insight into that and the way we're thinking about it right now as we develop an approach to the policy elements in this effort funded through the Common Fund at the NIH, which I keep being reminded, and as was just mentioned, is intended to be a program that could completely fail and that would, quote, be okay. Although I still find that people that work with me like to get a paycheck at the end of the month, and when things fail, sometimes that leads to other issues that are disconcerting. What happened was they funded a coordinating center, which includes a number of us in a virtual effort. And then 7 trials have already been funded, which are going through a phase right now of planning with a plan to assess whether they're ready to go out of the gate in about 9 months. So if you look at this, what you see is it's almost like a textbook of medicine. Almost any type of problem you can imagine is in here, and it's going to be a great test of multiple ways to approach this effort. So as we looked at it, it just seemed like it was an amazing time that so many different groups, federal agencies, private groups, all were interested in the same issue. And it's been, I think, very evident today that there's a confluence of interest of people who are really thinking about the meta picture that they would like to make this work. And so part of our job in the coordinating center is to learn from all these different groups, not just the demonstration projects that we have, but all the things that you've heard about, try to create a public record of what the knowledge base is and make it available to others that want to join in. Our great hope is that there'll be a tipping point as we learn so that policy and practice can become more integrated. As we thought about this, there were 7 areas that we thought were important, essentially problems that needed to be solved, some of which are relatively technical, some of which are relatively scientific, but some of which are really mostly related to policy as far as I'm concerned, and how things should be framed for people to think about how they conduct their research. So in this virtual coordinating center, we have 7 groups that are charged with creating a public record of what's known about that area, both from the demonstration projects as they get done, but also from anything else we can find anywhere in the world that's useful. Rich has already talked about the concept of the distributed network. Several people approached me in the break about this, and I want to emphasize the view of this network is not that it's a fixed object that would be sort of a bureaucratic hurdle to get through, but that it's a flexible way for people to maintain what their primary purpose is and still help each other answer questions. And the exact form this takes as we work with the NIH relative to the FDA, I think, is going to be an interesting set of policy issues in and of itself. So the question is, are we in a policy window right now? And by that I mean, is it a time where policy changes could be made that will really move things along more quickly? I hope we are, because all these federal agencies are interested in private groups. My experience with practitioners and talking with them about this, as long as they're not losing money and they're not being held up to scorn by their administrators because they're not moving patients in and out of the clinic fast enough, they love to do research. And I would argue almost 100% of the time when we found a good question that the practitioners like, the research gets done. And I think we've already heard that trial participants are not the problem. Typically when they get asked to participate, they do it. All right, so then quickly then, the 3 main areas that I think I'd love to make progress on in the discussion today. First, the technical policy issues. I would argue we no longer have the question of can we aggregate electronic records. We can do it. It may be clunky, and there was good discussion about some of the issues related to the type of programming you need, et cetera. Can we identify phenotypes using current electronic records? There are multiple groups that have shown that we can do this, that you can get relatively high quality data when you want to. Is it easy to do? And if people worked on it together, could great progress be made? Yes, I'd say the answer to that is absolutely. So the question policy-wise is what policies will move us more quickly to collection of standardized, reliable data that could serve as a backbone for a learning system that I would argue would include large sample trials, but would be mostly a quality system that just measures quality all the time. And we heard several versions of that today. But I think in the collaboratory, what I've already learned from talking, and it's a strange position for me to be in because I'm used to doing clinical trials. In this case, I'm watching other people try to do their clinical trials and talking to the PIs as they go through what it takes to really, on the ground, make it work. Far and away, the #1 issue is a combination of health system interactions that we've already been talking about and the issue of the regulatory ethics issues. So what policies would increase the probability that the things that we've talked about in the last session would actually happen at a faster rate? On the regulatory front, there are very specific questions coming up. Can we really streamline ethical review and institutional requirements, and realizing now that we're increasingly understand those two are not exactly the same thing. People that work in a health system or an institution have to protect their institution for a variety of reasons that are not their fault. A lot of this has nothing to do with ethics. It has a lot to do with protection from lawsuit and other kinds of mishaps that can occur, especially in the U.S. Can the FDA actively encourage streamlining as opposed to passively letting it happen? Is there a way that we could really hasten the regulated part of this? And will the key federal agencies encourage novel approaches to IRB and consent, something that's very hard to do because questions always get raised? And then finally, the ethics, which I think is where a lot of the discussion is going to go, because as we move to larger trials a la Mike Lauer with a lot of cluster randomization, one of the more interesting questions that the collaboratory is facing in a number of its projects, when comparisons are made between therapies or strategies that are already in use, and it's not known which is better, and cluster randomization is used as individual consent required. And what I've learned in talking with the PIs is that you can ask 10 IRBs and get 6 different answers to that question right now in the United States. And when a comparison is made using individual randomization, can we directly address optimal consent procedures as opposed to what's been happening, which is just continually making the consent forms longer and longer as people think of more ways that one can get in trouble legally at the institution. And then the final one, which I think is really the big question that's the core of everything we've been talking about, given that we now know that many people are harmed because we fail to answer obvious critical questions about which therapies and strategies are most effective for which patients, is the underlying construct of separation of research and practice appropriate and reasonable? And I'm hoping our panelists will give us insight into this. So the final slide, I think the theory is there, the technology is there, but Yogi Berra, I think, said it well. In theory, there's no difference between theory and practice. In practice, there is. So we got to actually get beyond the theory and get down to the practical aspects. So Ruth, are you up? Yes, please.
Good morning, everybody. I'm really pleased to be here, and I thank the Roundtable and the Forum for the opportunity. And Rob is an excellent chair, has organized us well. The question that was on your next to last slide about whether the separation of research and practice is ethically appropriate. So I have a quick answer, right? No, it's not. For nearly 3 years, a group of us has been struggling with that question. We're really clear on the answer, but it's a complicated one, and I don't think I can spin it all out now. I do want to acknowledge my colleagues in this collaboratory, this ethics collaboratory, a very small one. Nancy Cass, who many of these names are going to be familiar to you, which is why I'm sharing it. Nancy Cass, who's my co-PI on this, Tom Beecham, Steve Goodman, Peter Pronovost, and Sean Tunis, and the 6 of us have been trying for close to 3 years now to see if we couldn't come up with an alternative way of thinking about the relationship between clinical research and clinical practice. Our major findings, this is what Rob's going to press me on, are slated to appear in 2 papers in the January-February issue of a major bioethics journal, an area in our field, the Hastings Center report. Timing and publication constraints kind of keep me from giving you the details of our findings, but I'll be talking around them, and also I did want to acknowledge that what I say today is really not my work alone, but the work of all 6 of us and some other wonderful people who've been supporting us. So I only want to make 3 points in my remarks and then leave plenty of time for discussion, because that, I think, is what people want, or at least that's what we've been told you want. So you better want it, right, is what it is, because that's what you're going to get, right? So 3
Don't worry,
points.
you're going to get questions.
That's what I hope. All right. First point. First, there is a fundamental disconnect. It's really important to emphasize this. There is a fundamental disconnect between traditional approaches to research ethics and a learning health system. The traditional principles that are the cornerstones of research ethics were cemented in the 1970s. This was a time, many of us can remember, not all of us, but some of us, a period of intense societal focus on civil rights. And from the standpoint of research, it was a time where there was tremendous appropriate public appropriation and concern about egregious violations of rights, of human rights, that occurred in research, in highly publicized research scandals. That was the context in the 1970s. In the 1970s, the overriding concern was to protect patients and other research subjects, but let's focus on patients, from risk, from abuse, and from the unjust distribution of burdens of research in contrast to practice. So if the focus was how do we protect people from what might be abuses of human rights in research, right? We need to set up an oversight system intended to target it to that particular societal objective. In order to do that, right, we need to have a way to distinguish research from practice, because it's research that we're trying to protect patients' rights and interests in. Right? That's the problem. And the National Commission that was set up in the 1970s by Congress, spurred by these egregious research scandals, of which the Tuskegee, not really experiment, but the Tuskegee Research Project was the iconic symbol, but there were others, right? The focus was on how awful, right, the rights of human beings could be violated, how awfully in research. So we need to set up a system that's going to protect against these abuses, knowing that research is a good thing. We wanted to go forward, but we need to protect against these potential egregious abuses. To do that, we need to come up with a way to distinguish research from treatment. And indeed, one of the major reports of that National Commission provided an operational definition of how to distinguish research from treatment. And that's the complicated basis that we have today in our IRB system that has remained with us. So the dominant paradigm in research ethics and in federal regulations that emerges in the 1970s and that stays with us till today is relying on drawing a really, really sharp distinction between research and practice. It has to. It's in the logic of that paradigm. Is everybody with me? Okay. Now, by contrast, for what we think, and Rob's already laid out some of the rationale for this argument, for what we think are really good ethical reasons, a learning healthcare system proposes that it is not only acceptable, but indeed essential to integrate research and practice. So you have a dominant paradigm in research ethics and regulation built on, right, a foundation of needing to separate and distinguish research from practice. Now we're arguing that actually as an ethical matter, research and practice should be integrated. To do that, we need a way of thinking about the ethics of clinical research in healthcare that's completely different, right, from the paradigm that has framed how we have structured our thinking for 40 plus years. Another way of thinking about it is we need a different way of thinking about the relationship between research ethics and clinical ethics. So that's how we would frame it in our world, the ethics of how you ought to take care of patients and interact with patients, and the ethics of how you ought to do research.
I notice that everyone is paying attention right now.
All right. So that's my first point. I think I'm preaching to the choir here, is my guess, but we'll find out. So my second point is that the dominant paradigm relies on a series of empirical assumptions about how clinical research is different from clinical practice. And that's sort of the foundation, in ways that are ethically relevant. So it's not just ways that are different just because blue is different from black, but in ways that make one enterprise ethically different from the other enterprise. So these are the kinds of assumptions that I think you'll be familiar with. For example, it's generally assumed that clinical research puts patients at greater risk than clinical practice, that clinical research imposes greater non-clinical burdens, burdens that are not associated with their care on patients, that patients that get their care through clinical research may get less good clinical outcomes than patients who get their care outside of research, or that there are more restrictions on clinician judgment or on patients' choice in clinical research in contrast to clinical practice. These assumptions are questionable at best. I suspect that there are many large, simple trials, for example, of the sort that have been discussed yesterday and today, that provide excellent counterexamples to at least some of these assumptions. So one way going forward to go about rethinking the ethics of clinical research and the ethics of clinical practice is to challenge these empirical assumptions. It's a critical thing we have to do now. And here's my third point, though. Being able to demonstrate that patients are no worse off or even better off in terms of their medical outcomes if their care is embedded in research or research is embedded in their care, indeed it's integrated, is critically important. But from an ethics standpoint, it's not enough. The moral requirements that have grown up around this traditional paradigm, like the obligation to solicit first-person informed consent, are in place on ethics grounds, not only to protect patients from risks and the burdens of clinical research, but also, and this is really, really essential, as a way of showing respect for patients and honoring their absolutely necessary role in generating knowledge. That is, we solicit people's consent not only because we think they are in a position to help protect themselves against being inappropriately harmed or burdened, but also because we acknowledge that they're human beings, they're people, right, about whom we care and for whom we have to have foundationally respect. So before large, simple trials can ethically proceed, let's say in a cluster randomized design, without express informed consent for each patient for each trial, or indeed, say, a large, simple trial that doesn't involve cluster randomization, but randomization of the patient without the complicated consent process that's now required, we need to find a way to show, we need to find other ways, is a better way of putting it, to show that respect and honor that role. So it's not enough to show that the patients won't be harmed, that they're no better off, no worse off, and maybe even better off than they would be in clinical practice outside of this large, simple trial. That's a necessary condition for the ethics, but it's not a sufficient condition. We also need to find these other ways, right, to show that respect. Any new ethics framework for learning healthcare must include both a commitment to respect patients, respect for patients, and a commitment on the part of patients to contribute to the process of knowledge generation. That commitment has to be solicited, not necessarily trial by trial. Right? So there's got to be this kind of reciprocity, and that reciprocity between obligation to respect patients and patients' commitment to participate in research, that needs to be expressed through all kinds of practices that we need to determine, like practices of transparency, disclosure, oversight, that are acceptable to patients, right? Involving patients in a different way than we are used to involving them, because we now have a different venture that we're undertaking. And this is going to be hard work, right? I know yesterday, and I'm so sorry to miss it, there was a very good discussion about partners' perspectives in large, simple trials. And I know that that conversation illustrated some of the issues that need to be addressed. There's hard work that needs to be done if we're going to fill out this new way of thinking about the ethics of clinical research and clinical practice in this integrated way. But I think it's work we can't escape. So I'm going to stop there. Thank you.
Great. That's an amazing amount of wisdom and knowledge in a very short period of time. So I look forward to the discussion.
I don't know about that.
Devin.
Okay. I'm also going to go without slides. I'm an attorney, and my slides are the most boring things you'll ever see, so I'm going to spare you the slides. And instead, I've just prepared a few things to talk about. So I am a privacy advocate by definition in terms of my title. But to me, advocating for privacy in the context of thinking about how we can access, use, and disclose health data, and doing that advocacy on behalf of patients and consumers, to me means you have to think about privacy not as a mechanism for keeping data out of people's hands, out of the hands of people who could actually be using it to do some good, but instead thinking about really the interests of patients and consumers and actually having health data utilized to help them, to help their families, to help others like them, and contribute to improving the quality, reducing the cost, and improving the efficiency of our healthcare system. This is a vested interest of patients and consumers, and far too often we tend to think about privacy issues in terms of sort of, it's us versus them, right? It's either privacy or it's data access. And so what we try to do is think about how do you create rules around data use that respect the patient's interests, but also facilitate the use of that data for the purposes for which we want and frankly need to use it. And so that's sort of the orientation that I bring to thinking through these issues. And now my portion of this presentation is going to focus less on the ethics and more sort of on the law, on the policies that actually apply to the data use, which have ethical underpinnings, but as usual, we lawyers have made them much more complicated. So HIPAA is, of course, one of the rules that applies to research uses of data. It's not the only one, but it's a pretty big one. Because it applies to really to most of the data sources that we need. Not the patient-centered data sources, not patients like me, which Sally works for, but generally hospitals, providers, and health plans, which are the richest sources of data that we need to do this work. HIPAA is complicated, but if you really wanted to apply the KISS principle in its most extreme, it really does kind of divide data uses into kind of two big categories: routine and non-routine. And the routine uses, using data to treat a patient, using data from one patient to treat another patient, using data to get paid, using data to do what are called healthcare operations, which is a pretty big list of routine uses of healthcare data by healthcare providers and payers. All of that is considered a routine use, and all of that can be done not only without needing to get the consent of the patient first, but the patients can't even opt out of having their data used for those purposes because it's considered to be part and parcel of the business operation of a healthcare provider and a healthcare plan. They need to use the data for these purposes, and therefore we're going to place very few constraints on those uses. If you look at the non-routine uses, those are sort of, uses of data that are not routine or may be seen as extraordinary. Research is one of them. Marketing is another. Some law enforcement uses is another. And pretty much any other sort of commercial use that you can imagine needs to get the patient's authorization before you can use data for that purpose, and it's an explicit authorization. It has to be very specific to the particular use, to the person or entity that's getting the data. So you can see this dichotomy between sort of routine versus things that are viewed as non-routine, unusual, extraordinary, things maybe that a patient would not necessarily expect, be surprised by, and should have the right to have some say in whether the data is used for that purpose. So how does HIPAA draw the distinction between sort of the routine use in operations, for example, and research? Well, research is a use of data that's intended to contribute to generalizable knowledge. And so one of the classic examples of how this ends up playing out is the difference between a use of data for quality improvement processes, which is operations when it's intended just to be used internally, selfishly, to use another, to borrow from another presentation, and it's research when the intent is to use it to contribute to generalizable knowledge. So it could be the exact same use of data in terms of what data gets accessed, who actually accesses the data, what are the questions being posed. But if you're not going to share those results with anybody else, it's internal operations, it's routine, and there are very few constraints on it. If you intend to share the results with somebody else, it kicks it into research, and you all are well familiar with the provisions that apply in those cases. If we want to create a learning healthcare system, this distinction makes absolutely no sense. Same data use, same amount of access, but hoard the results and don't tell anybody about it other than your peers within your institution or your integrated delivery system. It's treated one way. Share the results with the world or intend to share the results with the world on some level, and you're in the research bucket. And that is, I think, enormously problematic. This suggests that one potential solution for dealing with this issue, at least with respect to quality improvement types of activities, and what's the definition of quality improvement? That's actually one worth thinking through what that encompasses, is to build the case that it is a routine use of data, or create a set of criteria or factors which distinguish it when it's done in certain ways, when it's done to address certain issues, when it's done consistent with, building a new paradigm for a routine use of data that contributes to the learning healthcare system. So that either it's not considered research at all and it's considered operations if we feel the need to continue to retain these buckets within HIPAA, or we think about a different way of framing it. We've sort of boxed ourselves into this situation where we're not judging the use of the data in ways that think about sort of traditional data stewardship types of issues, like how many people get to access this and what's the level of identifiability of the data and what kind of data security have we built around it, but instead just this issue of whether or not we're sharing the results with the outside world. It really absolutely makes no sense. So I'm very interested in being part of some continued efforts to think through what it would mean to create a class of uses of data that we build the case for being routine, and how we would do that, and how we would get greater public buy-in for that, and what sort of legal rules or systems of accountability would we put in place so that we can assure the public that treating these uses in this way does not mean we're sort of taking our hands off and saying, do whatever you want to with it, right? We've got some ethical and legal frameworks and systems of accountability in place to make sure that this is all taking place in an acceptable way. Fair information practices are a set of principles that apply to uses of personal data, whether it's healthcare data, financial data, and it's really the foundation for most laws that exist both nationally and globally with respect to how data gets used. It's the foundation for HIPAA, quite frankly. It's a little bit like fair information practices on steroids, but that's where the underpinnings are. And the issue of the individual's right to consent to uses of data, number one, is not absolute in fair information practices, and number two is only one of a number of other principles that largely have been ignored or undervalued or underemphasized in terms of how we create sort of policy frameworks to govern data use. Openness and transparency and an engagement of people in ways that goes beyond asking their consent, but is instead about involving them in, say, decisions about what research gets done and telling them about the results of research in a more systematic way, letting people know that when they are cared for, that their data is going to be used to improve the healthcare system, and it's going to be used in a responsible way. It's going to be used in lesser identified form to the extent possible. It will be exposed to the minimum number of people who need to get it. Distributed networks is another mechanism for ensuring that data doesn't sort of end up in places where you can't control its subsequent use. I think there are a number of elements to think through what a different way, what it would look like to regulate this in still a very trustworthy way, but a different way. And one of the things that I've taught, ripping and replacing one set of regulations with another is pretty much a non-starter in you know, if you decide you want to go big, right? Let's just get rid of HIPAA. I'll do credit to the IOM workshop who went down that road initially and said, you know, we can't deal with this anymore. We need a completely new regime. And I can understand why, but piloting new approaches and studying how well they work, I think, and creating, you know, again, a framework or a set of criteria that would apply makes sense, and I think would be something that a number of policymakers would find appealing. And we can talk about whether or not we think there's enough authority that already exists, or whether this is something we might have to seek some help from in terms of legislation. But I also think that this is an issue that you could get patient groups to rally around, and I also think you could get consumer groups. You know, people who care about the quality of the healthcare system generally, but don't have a vested interest in necessarily in research on a particular disease or condition, but are coming more increasingly to the understanding that the healthcare system that we have today, even though we're trying desperately to add more people into it, is untenable.